Hi, and welcome to Creepy Crime Story, where the darkest truths aren't imagined. They're real. No 911 call, no shouts in a hallway. A compact car sitting at a slight angle, collecting dust, one tire losing air, and a string of online messages that didn't sound like the woman who supposedly wrote them. This is Ashburn, Virginia. Here, the loudest warning can be the quietest absence. On January 29, 2011, Bethany Ann Decker, 21 years old and approximately 5 months pregnant, completed a routine step. She confirmed an upcoming shift with her employer. That phone confirmation is the last verified contact attributed to her. At the time, Bethany was legally married to Emil Decker, a member of the Army National Guard who had recently been on leave and would soon return to deployment. She was living at an apartment in Ashburn with a boyfriend. The next indicators that matter in a case file are simple: attendance, movement, and money. In the days that follow, Bethany does not appear for classes, misses work, and produces no corroborated in-person sightings. The vehicle tied to her remains in the apartment complex lot. It is described as parked imperfectly, noticeable enough for family and investigators to remember it, and developing dust with a flat or soft tire consistent with inactivity. There is no publicly documented 2011 blood scene in the apartment, no forced entry report released to the public, no immediate forensic strike that explains the disappearance. What investigators have at this opening stage is a baseline: a final call, a fixed location, a stationary car, and a young woman whose routine stops without explanation. In no body cases, baselines are everything. From a procedural standpoint, this is where a linear build begins. Establish timeline. Lock the last persons to have verified contact. Audit communications attributed to the missing subject. Assess whether digital activity reflects the subject's established patterns or a change in author voice. For Bethany, friends would later question the tone of certain Facebook messages. That skepticism, however, is not a conclusion, it's a lead. The task in Chapter 1 is not to solve the case. It is to fix the starting point so nothing drifts later. The opening file therefore holds to 4 defensible pillars: last verified contact, Jan 29, 2011 residence, Ashburn apartment, the car's non-movement, and the absence of a publicly confirmed physical crime scene in 2011. Nothing more is inserted here. No invented texts, no imagined surveillance, no speculative witnesses. The discipline matters because no scene cases are built by subtraction. When ordinary data stops, the silence itself becomes an exhibit. As one investigator put it, the data align too cleanly. Sometimes that was the problem. If you were first on this case, which dataset would you pull first? Work schedules, campus access logs, or social media author patterns? When a person vanishes, the first credible signal often isn't a scream. It's a missed obligation. In Ashburn, Virginia, the absence started to stack. After January 29, 2011, Bethany Ann Decker did not appear for scheduled classes and did not report for work. That pattern triggered the formal missing person process on February 19th, when family contact attempts failed and the gap could no longer be explained by ordinary life. From that point forward, the work was procedural. Verify what did not happen. Investigators moved to lock the baseline with documents rather than impressions. Employment confirmed her last verified phone contact on January 29th regarding an upcoming shift. Academic records reflected non-attendance after that date. Routine communications, calls, texts, messages attributable to Bethany, did not resume in any way that could be independently verified. The question wasn't why she would disappear. The question was why every system she normally touched went quiet at once. This chapter's discovery is the forensic value of negative evidence, using the absence of expected activity as a measurable indicator of harm. The unit did not speculate about motive. It did not leap to scenarios. It ran a standard sequence. First, determine whether the subject's digital trail continues in a pattern consistent with that subject's known habits. Second, confirm whether any third-party systems, employer scheduling, university systems, financial institutions, register independent proof of continued life activities. Third, reconcile those records against the last corroborated contact time. In Bethany's case, the reconciliation didn't hold. Everything went flat after January 29th. Social media activity introduced a separate line of inquiry. Friends and associates reported that some Facebook messages did not sound like Bethany. That is not a verdict on authorship, it is an anomaly. In a nobody case, anomalies do not answer the core question, but they change how the question is examined. The case team flagged those messages for later linguistic comparison and attribution checks against known writing patterns. The aim was narrow. Determine whether the account activity represented Bethany herself or another party using access. Any conclusion had to wait for corroboration. The practical impact in February 2011 was to widen the scope of record requests. In towns like Ashburn, disappearances don't just touch families, they change how a neighborhood reads the ordinary. The hallway becomes a timeline, the parking lot becomes a clock. But the narrative does not drive the file, the records do. Attendance logs, shift rosters, and communications audits established that Bethany's everyday rhythm stopped. There was no documented reappearance at campus, no verified in-person contact with colleagues, and no independent third-party confirmation of her presence after the last call. In a report, that is not rhetoric. It is a foundation, the kind that either cracks under scrutiny or supports a charging theory years later. The case classification remained disciplined. There was no publicly documented physical crime scene in 2011. There was no body recovered. The absence itself became evidence. That is an uncomfortable reality for viewers and families because absence feels anecdotal. In investigation, however, absence can be quantified. Dates missed, records silent, devices inactive. Measured correctly, negative evidence is not guesswork. It is a timeline under oath. As one investigator put it later, the data aligned too cleanly. Sometimes that was the problem. Too clean means no stray purchase, no unexpected login, no credible sighting to reset the clock. Responsibility in this phase is simple. Fix what is certain and do not exceed it. Certain, last verified contact on January 29th. Certain, non-attendance at school and work afterward. Certain, no independent documentation that Bethany resumed routine life. Certain, the social media voice concern exists as a reported discrepancy, not a settled fact. Those pieces form a coherent picture without adding drama. They justify deeper warrants, expanded interviews, and a broader look at who had access to Bethany's accounts and living space. They also justify holding back names and theories until the record, not a narrator, supports naming. This negative evidence block matters because it explains why the case endured. If you watch a lot of true crime, you know how quickly rumor tries to fill silence. This file resisted that gravity by staying narrow. Time, attendance, attribution. For families and communities, that discipline has value. It protects the integrity of the case, and if justice comes later, it protects the result. If you were sitting with this file in late February 2011, which anomaly would you prioritize first? Attendance failure, communications attribution, or third-party confirmations? By the third week of the disappearance, the file pivoted from "Is she missing?" to "Who had lawful access to her life?" This wasn't about suspicion by rumor, it was a proximity and opportunity review. Names, doors, schedules, and verifiable presence. When a case lacks a physical scene, investigators tighten the circle by mapping who could enter the space without force and who could plausibly interact with the victim during the last confirmed window. The relationship picture was factual and limited to what could be documented. Bethany Ann Decker, 21, was legally married to Emil Decker, a member of the Army National Guard who had recently been on leave in late January 2011 and was due to return to deployment in early February. That is a time-bound presence. Orders and travel confirmations are standard military records, and, when available, they anchor where a spouse was expected to be and when. Parallel to that legal status, Bethany resided at an Ashburn apartment with a boyfriend. Lease, mail, and utility records help confirm residence without speculating on the state of the relationship. These lines are not commentary, they are factual pillars that define who lived where. From there, the team built an access matrix. Who had a key issued by management? Which names appeared on the lease or were recognized by staff as regular occupants? Did maintenance enter in that period for scheduled work? These are routine questions in missing person investigations because they set the pool of individuals who could be inside the unit without leaving signs of forced entry. Common area access is also relevant. Entry doors, mailrooms, stairwells. If a property maintains logs, fob records, or work orders, those can shrink a timeline quickly. If a property does not, investigators move to sworn statements from management and residents, then cross-check those accounts against known dates. The analysis also weighed the difference between proximity and contact. People can live in the same household but not be physically present at the same times. The job is to verify presence with a document trail, work schedules, travel confirmations, school attendance, or credible third-party statements made near in time to the events. With Bethany, the last verified contact remained January 29, 2011. That date fixed the outer wall of the timeline. The question for this chapter was narrower. Among individuals tied to the address, who could have seen or reached her around that time, and can any claimed movements be confirmed independently? Digital access was treated separately from human access. In Chapter 2, we flagged social media messages that friends said did not sound like Bethany. Here, the operational question was simple. Where were the devices typically used to access her accounts, and who had practical access to those devices? That is not the same as saying who typed a message. It is a location of use and custody review. If a roommate or partner had routine use of a shared laptop or an unlocked phone, that changes how attribution is tested later. It does not assign motive. It frames the technical inquiry. Interviews moved outward in concentric circles. Property management, close friends, roommates or partners, family, and coworkers. The language in those sessions mattered. Investigators asked for verifiable facts, dates, times, receipts, not impressions about the relationship. The purpose wasn't to produce a theory. It was to fix an access map and a presence calendar. Claims of travel were matched to tickets or orders. Claims of being home were tested against calls, messages, or credible third-party observation. In a nobody case, this is where the file earns its structure, because each verified minute reduces the surface area for speculation. One point often overlooked by observers. Access reviews also include who did not have easy entry. Casual acquaintances, distant classmates, former coworkers. If they lack keys or a reason to be inside, they fall to the edge of the map unless a separate lead pulls them back in. That matters because public attention can drift toward dramatic theories. The access matrix resists that drift. It keeps focus on the people whose presence is administratively documented, domestically routine, or consistently reported by others as part of the living situation. This chapter's forensic gain is modest and critical at once. Proximity narrowed. The address was not a vague backdrop, it was a controlled space with a finite number of regular entrants. Emil Decker's deployment window set a documented time frame for his whereabouts after leave. Co-residency at the Ashburn apartment established who had routine, lawful access to Bethany's living space. Those facts are not conclusions about conduct. They are levers for the next steps. What devices were where, whose accounts were in use, and which statements align with independent records. A quick note for those following along because they care about victims, not just cases. Proximity reviews can feel impersonal, but they exist to protect truth. They prevent rumor from hardening into memory. They limit harm to families who are already carrying enough. This kind of discipline is a form of respect. Two practical inferences close the chapter. First, access narrows faster than motive. That's by design. Second, without a physical scene, the point of access becomes the map. The next stage would move from who could be there to what the data says about who actually was. In cases built without a traditional scene, the first decisive gains often come from systems that don't lie: devices, accounts, and third-party records. After the baseline and access map were fixed, the Loudoun County investigation moved to a structured digital audit. Subscriber data, account activity windows, and any independent signal that placed Bethany and Decker in motion after January 29, 2011. The approach was conservative. No dramatics, no leaps, just records. The team requested employment schedules and confirmed the last verified call already on file. They expanded to communications providers for historical logs and to social platforms for account metadata. The question set was narrow. Did routine logins occur from expected environments? Did the pattern of usage continue in a way consistent with prior weeks? Did any travel-linked transactions appear that would force the timeline forward? Silence across independent systems is rarely coincidence. When it appears, it has to be tested from multiple angles to ensure it isn't a data artifact. Friends had already reported that some Facebook messages didn't sound like Bethany. Rather than treat that as a conclusion, the case treated it as a technical problem, attribution. Investigators compared known writing habits to the phrasing in the question posts and examined whether access to her devices or saved credentials inside the apartment could explain those posts without requiring her physical presence. This isn't about proving authorship in Chapter 4. It's about deciding whether the messages are strong enough to reset the clock. They were not, at least not yet, because attribution without independent corroboration is fragile. The working position remained that January 29th is the outer wall until a separate system contradicts it. From a method standpoint, device history matters even when exact content is unavailable. Phones, laptops, and tablets carry rhythms. When they're active, where they connect, how often they interact with familiar networks. A sharp break in that rhythm, aligned with a missing person timeline, is not just absence, it's pattern loss. The case file distinguished between two questions that often get blurred by the public. Where is the person? And where are the devices that impersonate the person's voice? That separation is crucial in a nobody case. If a partner or roommate had routine access to a shared computer or an unlocked phone, then unusual posts alone cannot move the last seen marker. Financial data was reviewed next because it can disprove assumptions quickly. Regular purchases by a college student and expectant mother, groceries, gas, campus costs, tend to leave clean footprints. The absence of those footprints after a fixed date is meaningful, particularly when neither campus nor employer registers activity either. The file's value here wasn't that finance proved harm, but that it failed to prove continued ordinary life. When employment, school, communications, and finance all point the same direction, and none independently push the date forward. Investigators can justify a broader set of warrants and interviews without risking confirmation bias. Neighborhood and property checks had already suggested little disturbance at the apartment complex. That finding stayed in place, and it guided the digital work. With no documented 2011 physical scene and no body, the logic was simple. If the world could not confirm Bethany in person, it would have to confirm her in data. When the data refused, the absence itself became a structured exhibit. Not speculation. Entries in a ledger, last call verified, thereafter no independently corroborated sign-of-life event. It's worth saying clearly, restraint is a form of accuracy. There were no public releases in 2011 about recovered DNA, blood, or a violent scene inside the apartment. There were no official statements about recovered remains. The evidence block in this phase consisted of negative indicators and attribution questions, and it is exactly that block that later allows a prosecutor to speak in court with confidence about a life that stopped, digitally, financially, and behaviorally, on a specific day. From a human perspective, these chapters are heavy. Families are asked to wait while investigators read silence like a ledger. Communities want speed, the file wants proof. In towns like this, crimes don't just wound families, they disturb the trust that ordinary routines will always resume. Precision protects that trust. It keeps the narrative aligned with facts that can withstand court review years later. This digital review closes with one guarded inference and one next step. The inference, nothing reliable resets the clock beyond January 29, 2011. The next step, press deeper on device access and account control. Who used what, where, and when, so proximity can be separated from presence. That distinction will matter when the case transitions from missing person to a charge supported by circumstantial but coherent proof. Ashburn stayed quiet, but the case didn't. 3 years after the last verified contact in January 2011, a separate file in a different state forced its way onto the radar of Virginia investigators. In Pinehurst, North Carolina, 2014, Police documented a serious assault involving Ronald D. Roldan and a different woman. The incident was prosecuted in North Carolina. In 2016, court records show felony assault convictions and a 6 to 8 year sentence. The Loudoun County team logged the outcome, not as proof of what happened in Ashburn, but as a documented pattern of violence relevant to future charging and evidence strategy. This mattered for one reason. When a missing person case advances without a physical scene or recovered remains, prosecutors rely on circumstantial strength. Timelines, digital silence, behavioral indicators, and, where the rules allow, pattern evidence to explain motive, intent, or absence of mistake. The North Carolina case was an external data point with a certified paper trail. It did not resolve what became of Bethany Ann Decker. It did change the questions investigators were allowed to ask with more urgency. Who had control in her daily life? What did escalation look like in relationships tied to the Ashburn address? Which facts could be argued to a Virginia judge as probative rather than prejudicial? The Virginia file stayed disciplined. No body homicide work is slow by design. The team did not collapse two jurisdictions into one narrative. They separated them cleanly. Ashburn, Loudoun County, Virginia, 2011 disappearance, and Pinehurst, North Carolina, 2014 assault, 2016 felony pleas. That separation preserves accuracy and prevents contamination of the timeline. Within that structure, the Loudoun case notes highlighted the following operational benefits from the North Carolina outcome: a verified account of intimate partner violence, medical consequence documented by the court, and an offender identity already adjudicated in a criminal proceeding. Those are not rumors. They are certified facts a Virginia prosecutor can reference in motions practice when the time comes. The human reality is harder to read in a report, but necessary here. Families asking where Bethany is and what happened to her do not get relief from a conviction in another state. What they get, if anything, is confirmation that someone in her orbit later harmed another partner so severely that a different court had no difficulty delivering a felony judgment. That knowledge deepens resolve inside an investigative unit. It also informs risk decisions when a person of interest completes a sentence and returns to open questions elsewhere. Back on the procedural track, the Loudoun team prepared for two future fronts. First, admissibility. If a Virginia judge were asked to consider the North Carolina assaults as evidence, what rule and what theory of relevance would be invoked? Pattern evidence is not automatic. It requires careful linkage to contested issues like intent, lack of accident, or common scheme. Second, custody planning. When the North Carolina sentence wound down, how would Virginia assert its interests? Those logistics, warrants, detainers, transport, are where a cold case begins to warm without any press conference. Files move, people move with them. This chapter shifts the case forward without rewriting the past. The January 29, 2011 cutoff remains the last reliable marker for Bethany. There is no publicly documented 2011 physical crime scene in Ashburn and no recovered remains as of today's date, September 17, 2025. The North Carolina matter stands beside that reality, not on top of it. It supplies leverage when the Commonwealth later argues that what happened to Bethany was not a misunderstanding or voluntary absence, but the product of violence consistent with conduct already proven elsewhere. Narratively, it's tempting to treat the North Carolina outcome as the turning point. Legally, the turning point comes when a Virginia court says what the jury may hear. That fight is ahead. For now, the importance of this moment is strategic. It arms the case with certified facts that survive cross-examination and sentencing in another courtroom. It tells the Loudoun team that if they can align timelines, digital gaps, and access maps with a coherent theory, they will not have to explain to a judge why they leaned on gossip. They will rely on adjudicated conduct and a Virginia-anchored record. Cases like this test communities. In towns like this, violent crime doesn't stay in the abstract. It lands on doorsteps and in court calendars. Precision is the only honest answer to that kind of fear. Precision here meant keeping jurisdiction straight, using what was proven elsewhere only for what it could lawfully prove, and continuing to build the Ashburn file with the same narrow tools that opened it: time, access, and data. By late 2020, the paper trail in Virginia was strong enough to justify a move. Loudoun County sought and obtained a warrant for abduction tied to the January 29, 2011 disappearance of Bethany Ann Decker. The theory was not theatrical. It was built from the same pieces we've tracked since the baseline: verified last contact, sustained digital and financial silence, and a controlled access map. When North Carolina custody on an unrelated case approached its endpoint, Virginia filed the paperwork to ensure there would be no gap. Transport was arranged. Extradition followed. Booking in Loudoun County came next. The bond decision was simple: held without bond. A warrant is a legal statement that probable cause exists. In a no-body case, probable cause often arrives as alignment across independent systems rather than a single dramatic find. The charging documents in Virginia did not pretend a 2011 physical crime scene existed in Ashburn. They leaned on what could be proven without it. Timeline: fixed. Routine life markers: stopped. Device and account behavior: inconsistent with Bethany's known patterns. Access: limited to a small universe of people with lawful entry or regular presence. The absence of competing explanations: no verified sightings, no verified travel, no third-party confirmations, moved the file from missing to abducted in the eyes of the court. Once in Virginia, the process turned to preservation. Interviews were rerun with fresher memory aids, prior statements, work records. Digital warrants were updated to reflect newer retention practices. Property and management logs were revisited to confirm key issuance and maintenance entries around the last contact window. The point wasn't to invent new facts, it was to harden old ones against the scrutiny that comes with a courtroom. Separately, prosecutors began mapping how adjudicated violence in North Carolina, 2014 to 2016, might later be argued under Virginia rules as pattern evidence, if the judge allowed it. That preparation mattered, but it did not rewrite Ashburn's timeline. It stood beside it, not on top of it. Custody planning had an additional purpose: public safety and leverage. With the defendant now on a Virginia docket, the Commonwealth controlled scheduling, motions, and discovery pace. That meant the negative evidence stack developed between 2011 and 2020 could finally be tested in pretrial litigation instead of waiting out another calendar. It also meant the family would get what every family asks for in a long case: momentum that is real, not rumored. Nothing in this phase changes the essential facts. No body has been recovered as of September 17, 2025. There is no publicly documented 2011 physical crime scene in the Ashburn apartment. What changed was jurisdictional control and legal posture. The file moved from an investigative ledger to a charging instrument. And with that came the first formal opportunity to argue, in a Virginia courtroom, that the evidence of absence is itself evidence of harm. One short reflection before we move on: precision protects outcomes. In towns like this, cases don't just live in headlines, they live in court minutes. Getting the handoff right, from out-of-state custody to a Virginia charging document, was the quiet turning point this case needed. Inside a Virginia courtroom in 2021, the case paused for law. Loudoun County had custody and a charge, but before any juror could be seated, the record had to be shaped: what evidence enters and what stays out. Pre-trial became the arena where a no-body file either gains coherence or collapses under its own gaps. The defense moved first, asking the judge to wall off what happened in North Carolina years after the January 2011 disappearance of Bethany Ann Decker. Their position was predictable and legitimate. The 2014 assault and the 2016 felony pleas, there were separate, prejudicial, and risked inviting the jury to convict by character rather than proof. If the Ashburn timeline stood on negative evidence and access maps, they argued, then it should stand or fall on those elements alone. The Commonwealth answered with a tighter frame. They did not claim a 2011 blood scene in Ashburn. They did not claim recovered remains. Instead, they argued relevance under Virginia's rules. Certain prior acts can be admitted, not to prove a defendant is a bad person, but to show motive, intent, or the absence of mistake. In a case built from a fixed last contact date, sustained digital and financial silence, and a narrow access universe, they said the North Carolina violence helped explain why the absence meant harm and not voluntary flight. The point wasn't to retry another state's case. It was to give a jury lawful context for escalation in intimate relationships tied to the Ashburn address. The judge issued a measured ruling. The North Carolina assault evidence would be admitted over objection with limiting instructions. The jury, if this case reached trial, could hear that adjudicated conduct for the narrow purposes allowed, motive, intent, lack of accident, not to infer guilt from propensity. The order did not rewrite the Ashburn timeline. It did not relax the burden. It did one thing prosecutors prize in no-body litigation. It allowed jurors to consider conduct that a different court had already tested. With admissibility set, the posture changed. The defense now faced an evidentiary landscape where the jury could hear about a later, violent act, alongside a record showing no verified sign of life for Bethany after January 29, 2011, no independent travel footprint, and no publicly documented 2011 physical crime scene at the apartment. Prosecutors gained leverage, but also responsibility, to keep the presentation disciplined, to separate what Virginia could prove from what it could only suggest, and to respect the limits of the court's ruling. As one investigator remarked in notes, the task was simple to state and hard to execute. Context without contamination. Pre-trial also sharpened practical decisions. Witness lists were trimmed to those who could anchor dates or access. Digital custodians were lined up to explain retention and gaps without inflating what the data could say. The family was prepared for a process that values precision over speed. In towns like this, murders aren't just crimes, they tear at the fabric of a quiet community. Precision is the repair. Nothing about this ruling created a 2011 scene or produced a body. As of September 17, 2025, those facts remain unchanged. What changed was risk. Trials are about what the jury is permitted to know, and after this ruling, the permitted record was broader and stronger than it had been the day before. If you were leading this prosecution, would you front-load the pattern evidence instruction in opening to control how jurors hear it, or hold it for the court's charge, and keep your opening anchored strictly to the Ashburn timeline? 11 years after the last verified contact on January 29, 2011, the case finally moved from quiet suspicion to a courtroom certainty. In November 2022, Ronald D. Roldan stood before a Virginia judge and pleaded guilty to second-degree murder in the disappearance of Bethany Ann Decker. This wasn't the end of a dramatic jury trial. It was the point where the record, built from timelines, digital silence, and a tight access map, became a legal admission. In a no-body prosecution, that matters. It replaces speculation with a defendant's own words under oath. The plea came after years of disciplined work that never claimed a 2011 blood scene in Ashburn and never pretended a body had been found. The Commonwealth stayed inside the facts. Last contact fixed, no independently verified activity by Bethany afterward, no credible third-party sighting to push the clock forward, and a narrow universe of people with lawful access to her apartment. Pretrial rulings meant the jury could have heard a separate assault case from North Carolina for specific purposes, motive, intent, absence of mistake, had this gone to trial. The defense knew that risk. The plea avoided that trial. At the sentencing hearing on February 21, 2023, the court entered a structured result. 40 years, with 27.5 years suspended, leaving 12.5 years to serve, along with no contact terms and the weight of a felony homicide conviction. Virginia does not suspend time casually. The structure balanced the guilty plea, the absence of recoverable remains, and the evidence posture the Commonwealth built without a traditional crime scene. There was no victory lap. There was a lawful outcome. Families often ask the question the law can't answer: where is she? As of September 17, 2025, Bethany's remains have not been recovered. That unresolved fact does not weaken the conviction. It explains why the case demanded unusual restraint from investigators and the court. Every assertion had to be verifiable. Every inference had to sit on independent systems, attendance, communications, finance, rather than rumor. The record held, and the defendant chose to plead to second-degree murder. It's important to be precise about what this chapter does not change. There is no publicly documented 2011 physical crime scene in the Ashburn apartment. The Commonwealth never claimed to have found one. The case succeeded because the absence of ordinary life, measured, dated, and confirmed across multiple systems, was inconsistent with voluntary flight and consistent with foul play. The plea is the legal acknowledgement of that reality. Sentencing is the court's response to it. When we talk about true crime, we sometimes forget what true costs. In towns like Ashburn, a case doesn't only move headlines, it moves families, classrooms, workplaces, real places where Bethany was expected and did not return. The most disciplined thing an investigation can do for a victim is to speak with accuracy. That's what this file did. It never invented a scene, never promised a recovery it didn't have, and never let the narrative outrun the evidence. Precision isn't style, it's respect. There is also a broader message here that deserves one line and no more. If a loved one goes quiet all at once, work, school, banking, routine contact, don't wait for a dramatic sign. Silence can be evidence. Report it, document it. Push for verification early. Cases like this are built one confirmed absence at a time. The story you've heard is one continuous case. Ashburn, Virginia, a 2011 disappearance, a long, careful build, a 2022 plea, a 2023 sentence, and an unresolved search for remains today. No alternate endings, no detours, just the through line the record supports. If you followed us this far, one thoughtful question remains for the community. When a person in your circle slips out of their routine, what's your first verifiable step to make sure their silence is seen? Looking back on Bethany's story, I realize how silence can speak louder than words. When someone disappears from their routine, it's not just a gap in the calendar. It's a warning that deserves attention. My lesson is simple. Don't ignore the signs, and don't be afraid to push for answers. Justice came slowly here, and though her body was never found, her voice still matters. What about you? Have you ever noticed a silence that felt heavier than words? Share your thoughts below. Let me know where you're watching from, and if this story touched you, please subscribe so you won't miss the next case we uncover together.